Tuesday. My name is Ambassador Tahule Joshua. I'm the registrar of the Institute of Global Peace and Conflict Management, and this training is organized by the Institute to equip our followers on Facebook and on YouTube with the basic skills in conflict resolution through the alternative means of resolving disputes. And the training we are focusing on for this month is what we call alternative dispute resolution. Alternative dispute resolution is the professional diploma in alternative dispute resolution. And I would like to welcome all of you and also apologize for yesterday. We couldn't meet. I was just stuck in the traffic while coming back, and I couldn't just do otherwise. So I would like to appreciate all of you for taking time to be part of this month's training, and we hope that you are going to learn a lot of things from this training. And this training is organized by the Institute for free. From training to certification is free. You are not going to pay anything for this training. So far as this training is concerned, the only payment you are going to pay is your time and your data. That is the only thing. Apart from that, it's 100% free. So I would like to welcome all of you for today's training, and basically we're going to continue from where we stopped. So if you join us, you can introduce yourself. Let us know where you join us from, your name, the country, or maybe your location and your country. For instance, if you are from Kenya, you can say Nairobi, Kenya, and that's fine. If you are in Lagos, Nigeria, you can say Lagos, Nigeria. If you are in Abuja, you can say Abuja, Nigeria. If you are in Cameroon, help us to know whether you are in Yaoundé or you are in Cameroon. Do you understand? So that we will know. Yeah, so thank you very much for taking time to connect for today's training. You can do it to share this training for others to also take time to be part of. You can also share it in our WhatsApp group. You can share it with friends, family, loved ones, to also be part of this training and also learn what you're learning. It will help them in so many ways. All right? So today I would like to welcome all of you. Alabi Salihu, the first person to connect today. Mark Daniels Bolaji, and from Lagos, Gloria Ifyong, Elizabeth Carr, Bauchi, then we have Chinonso, Steve, that's fine. And on YouTube, I'm seeing Dr. Abdullahi Eko Ojo from Makwedi, Nigeria. Thank you for taking time to connect. Kingsley Agundu, Pastor Kingsley from Port Harcourt. It's a pleasure to welcome all of you for today's training, and we know that you are going to have a wonderful time. So if you join us, just let us know where you're joining us from, and let us know your name and where you're joining us from. We appreciate that, and it will help us to understand where people are connecting with us so that we can open the chapter there, because we are opening chapters in several countries, and we hope that it will get to your country very, 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 very soon. All right. So Edward Edeke Prince from Port Harcourt, it's a pleasure to welcome you. The people on YouTube, you're not talking. I'm not seeing your chat. Comment. Let us know your name, where you're connecting with us from. Lekan Shei from Lagos, Nigeria. Thank you. All right. So if you join us, let us know where you join us from as we study together. All right. Ajefu Sunday, thank you for joining us from Lagos, Nigeria. I am Hoba Favor, Lagos, Nigeria. It's like I have so many Lagosians in this class today. It's only Lagosians that are here today. All the Lagosians, thank you for connecting. We have Elizabeth Mary Ndura from Namibia. And Elizabeth, it's like you process. I discovered that Namibia, if you want to enter Namibia now, you have to get a visa. So it's like if people will process a visa for me, I want to go to Namibia. All right. Ambassador James Olugbo Hemi from Lagos, thank you for connecting. We're going to look at arbitration process. Arbitration process. Ambassador Fajobi Cecilia, thank you for joining us. Arbitration process. This is what we're looking at today. Elizabeth is not just welcome, it's visa I need. I need a visa to enter Namibia. I tell you, I need a visa. They're inviting me for a program in Namibia now, but I need a visa. And I need like 1.4 million flights to be in Namibia. All right, but that is bad way anyway. Let's proceed. Grace Meaton from Uganda, thank you for joining us. Thank you. We are looking at alternative dispute resolution, and we have looked at mediation in details. We are looking at arbitration. Briefly, we were able to explain what mediation is, arbitration, negotiation, conflict resolution. So today I want us to look at the process of arbitration. If you want to take your matter to an arbitration court, how do you go about it? How do you go about it? How do you go about it? If you want to take your matter to an arbitration center or arbitration court, how do you go about it? What are the processes that are expected of you to follow? All right. First thing we're going to look at arbitration agreement. All right. An arbitration agreement is a contract in which two or more parties agree to resolve dispute outside of court through arbitration. Now, you may decide to sign that agreement to resolve your matter outside the court. That is fine. Or there may be contracts awarded that may have a clause in it that in case of any dispute, the matter can be taken to any arbitration center or court in so place, or they can make reference to maybe ECOWAS arbitration center or AU arbitration center, or any of the international arbitration centers can, most especially if it's an international business. All right. In terms of, for instance, now you can enter into trade disputes or trade agreement with maybe an international business consulting, and then if there is a business dispute or in a process of agreement, because you foresee or you foretold that in case there is conflict or dispute, then this matter, the conflict or the dispute should not be taken to court. Rather, it should be taken to an arbitration court or arbitration center. Do you understand? And that agreement must be signed. So if for instance now, if I enter into a contract with us, for instance now, okay, in terms of dispute, it can be taken to arbitration court. It's as simple as that. So while we are trading, while we are transacting, if there's any dispute whatsoever, you can take, that's if it has been agreed upon. And if it is not, but you wish that your matter should be taken to arbitration court or center instead of the court, then it can be, the agreement can be drafted. Do you understand? So when it comes to arbitration agreement, there are three factors that we need to consider. One is drafting an arbitration agreement. You first and foremost draft an agreement that contain all the basics of that agreement, whatever the necessity that you want it to be contained in the agreement must be stated there. All right, so you draft the agreement considering all the components of the issue you are trying to address. Do you understand? And then you approach arbitration center or court. Clear language. All right, when drafting the agreement, you use what straightforward language, no ambiguity, no technicalities. You understand? No ambiguity, no technicalities. All right, use the simple language to reach your agreement so that people can easily understand it. Do you understand? Then scope of the dispute. In the agreement, you must state the scope of the dispute. Dispute over what? All right, is it contractual? Is it tout? Is it statutory claims or what? What is the agreement? What is the dispute that you are trying to resolve? So you must state the scope of the dispute, right? So you can include or exclude certain matters as needed. Do you understand? As much as needed, you can exclude certain things that are not necessary. So, but you can state the scope of the issue you are trying to address. All right, it's very, very important. All together. So when it comes to drafting the agreement, it must be clear language must be used. Scope of the dispute must be stated clearly. Do you understand? The second factor we're going to consider is arbitration rules. Arbitration what? Rules. Reference the rules governing the arbitration. For example, now we have the AAA, that is American Arbitration Association. All right, the Jamaican Arbitration Association, or ACA, Association of Chartered with Arbitrators, to provide a framework for the process. You understand? So you can make reference to those. If you are in America and you want to use them arbitration court or center in America, you can make reference to the AAA governing rules on arbitration. Do you understand? And it will help you. So arbitrator selection. So outline how arbitrators will be selected, including the number of arbitrators and any qualification required. Do you understand? If it is a professional matter that requires professional experience, then you have to get someone that has experience and has the needed qualification in that field. Do you understand? So in the areas of medical field, you have to get someone that may be a consultant who has, sufficient knowledge so far as medicals is concerned. Do you understand? Location. You have to indicate where the arbitration will take place. Nigeria, America, Ghana, Ethiopia, UK, Depends on the nature of the dispute. If it's in Nigeria, then there's no need, if all of you are in Nigeria, there's no need of taking your matter to Ghana. All right? Except you are going under the auspices of ECOWAS. Except you are going under the auspices of AU. Except you involve in international transactions that involve someone outside of Nigeria, that you can approach the International Arbitration Court. Do you understand? So otherwise, if you're in Nigeria, do it in Nigeria here. But if the partner to the dispute or a party to the dispute is in America and you are in Nigeria here, you can also deploy the online dispute resolution mechanism. All right, and that can be done. All right, so confidentiality, all right, include provisions regarding the confidentiality of the proceedings and any outcomes, costs and fees. All of these have to be included in the governing rules. Do you understand? So if you are going to pay the arbiters or the arbitrators $5 per hour or $10 per hour, it depends on the environment where you find yourself. Do you understand? If you agree that you can pay them a service fee of maybe at the end of the whole process, it depends on how you agree. But you must state the cost, clearly, so that everybody, the parties to the conflict or the dispute, understand what is involved. Then finality of awards. You have to state that the arbitrator's decision will be final and binding. So if that's the case, there will be no room for appeal. You understand? So you have to specify any limited grounds for appeal. Yes, if the decision is final and binding, then you can state under what circumstances the matter can be appealed. If it's not possible to appeal the matter, then it also has to be stated in the ground rules that the arbitrator's award cannot be appealed. Its decision, his words are final, and so it must be agreed. Or if there are exceptions and there are exceptional issues or considerations, then on those grounds it can be appealed, but you have to state them in case maybe there's element of doubt. All right, if there is element of doubt, then it's possible that you can allow such to be appealed. Do you understand? Validity of an arbitration agreement. Validity of an arbitration agreement. So legality. The agreement must comply with applicable laws. In the US, the Federal Arbitration Act, or in Nigeria, we have what we call Nigeria Arbitration and Conciliation Act. How many of us are aware of this act? The Federal Arbitration Act, that is for the America. For Nigeria, we have what we call Nigeria Arbitration and Conciliation Act. All right. So in America, we'll call it FAA. In Nigeria, we'll call it ACA. Do you understand? ACA provides a strong legal framework supporting arbitration agreements. All right. So before you enter into the agreement, and if there are rules governing the process and the process of arbitration, and you are in Nigeria, you have to make reference to the ACA, Nigerian Arbitration and Conciliation Act, so that whatever governing rules you are going to do out are in line and in tandem with the provisions of the ACA. Do you understand? It's very, very important. Then we'll talk about mutual assent. Mutual assent. That's both parties must voluntarily agree to the terms, evidenced by what signatures or other forms of acceptance So mutual assent is also that's no one should be forced to append his or her signature there. It should be voluntary. You have to agree voluntarily to go into arbitration, and the procedure must not show any form of compulsion. Nobody should force anybody to do something like that. Do you understand? So it should be that you go into it voluntarily, no coercion, no compulsion, no such kind of intimidation for you to sign for any reason. Do you understand? Thank you, Prince Ambassador Tamba, Yaoundé, Cameroon. Thank you for joining. He's a member of the Institute from Cameroon. It's a pleasure to have you. And also Dr. Emmanuel as well. Edururu Bosco from Uganda. It's a pleasure to have you. Thank you for connecting. Then consideration. There should be consideration, something of value exchange to support the agreement. Do you understand? There should be consideration. There should be consideration in case there is something to exchange for anything that should be done. Capacity. Parties must have the legal capacity to enter into the agreement. Age, mental competence. You cannot go and enter into agreement with an underage. You understand? It must be a person of a stipulated age as being contained in FAA or ACA. Do you understand? It's very important. I'm calling FAA, that is Federal Arbitration Act. And that is in case of America, and in case of Nigeria, Nigerian Arbitration and Conciliation Act. Do you understand? ACA. So you must consider that. Do you understand? Very, very important. So if you're just joining us, you can do way to share the link to someone, to post it on your wall, let others also see it and they be part of the program. You can also do way to comment, likes, and also paraphrase. What you're learning here is very important. Somebody's asking, is the course a certificate? It's a certificate course. We're going to give you a certificate at the end of the day, free of charge. You're not paying for it, okay? Training certification, free. So, thank you for joining. Scope of an arbitration agreement, but you must write the exam and pass. So if you don't write the exams, you don't pass, no certificate for you. All right. If you write the exam, you fail, you have to wait for the next batch that we're training people. So that's it. All right. Scope of an arbitration agreement. Scope of an arbitration agreement. Broad versus narrow scope. You can have broad or narrow scope. Broad scope, it covers all disputes arising out of or relating to the agreement, commonly used. Do you understand? So you have to make the issue so broad. Do you understand? They should even go outside of the dispute alone that you are trying to. It should be so broad in such a way that it can be able to tackle several angles of the matter. Do you understand? The narrow scope limits arbitration to specific types of dispute, which may be preferably in certain situations. Do you understand? So that's why you have to be broad in it so that you can go wide. Do you understand? You say you are interested. You are interested, you are welcome. All right. But Mr. Hossein, it's a pleasure to welcome you. You are still talking about tuition. You want to do a tuition training program or what? Or otherwise, for this one, we say it's free, and you are not paying anything. And If you want to find yourself in a WhatsApp group, because it's for all education, you do not register from the beginning, and we have gone so very far. All right. But it's in case you want to still be in our WhatsApp group, so next time you can have access to the next training that will be advertised for free. You can still reach out to us so that we will connect you. All right. Ambassador Vivian, Ambassador, thank you for connecting. All right. To Doko Steven, thank you. Nasir from Jos, thank you. All right. So, exclusions. Clearly state any exclusions in the scope of the arbitration agreement. Is there anything that you don't want to include in the scope, or you don't want it to be included in the scope of the agreement? Exclude it. You have to state it. Dispute relating to intellectual property rights, excluded, to avoid confusion about what is arbitrable. Do you understand? So you have to be very clear about it. Enforceability. Courts generally favor arbitration agreements. Courts generally favors what? Arbitration agreements. But the scope must be clear to ensure enforceability. Because if the scope is not clear, it can hamper the chances of enforcing the agreement. Do you understand? So ambiguities may lead to dispute over whether a particular issue is subject to arbitration or not. Do you understand? So that's why it must be specifically stated, especially stated, so that there will be no confusion. There are no challenges to know what you're trying to express. Do you understand? Then, so an effective arbitration agreement should be well drafted, addressing all essential elements to enhance its validity and enforceability. So you want to use arbitration and you want to enter into arbitration agreement, these are the things that you are going to do, and you must follow them cogently and with diligence. Do you understand? Selection of arbitrators is the next topic that we're going to treat. Selections of what? Arbitrators. How do you select arbitrators to arbitrate your matter? How do you select arbitrators to arbitrate what? Your matter. Selection of arbitrators. Selection of arbitrators is a crucial aspect of the arbitration process, as the arbitrator's expertise, impartiality, and decision-making skill can significantly impact the outcome of a dispute. So, key consideration for selecting arbitrators. Number one, before you consider selecting someone to be your arbitrator or to arbitrate over a matter that you are involved, what are the things that you're going to consider? Number one is qualifications and expertise. I made mention of this. I say if you are a medical, maybe the issue is a medical matter, so you have to get a consultant who has knowledge in the area of medicine, and then also in the area of law. Do you understand? So that's why we say it must be someone who is well experienced to arbitrate. So relevant experience why choosing arbitrators matters a lot. Do you understand? Specific industry or legal issues relevant to the dispute. So someone who possesses these credentials or attributes or traits can be used. Do you understand? So professional backgrounds. Consider their professional credentials such as legal education, relevant certifications, and experience in arbitration. Do you understand? It's very important that you get someone who has knowledge over arbitration, who knows what arbitration is all about and how it can be executed. It's not someone that has no idea what it stands for, or it's not someone who lack education, someone who cannot express him or herself very well, and then you want to make him an arbitrator. No, it's not correct. Impartiality and independence. Conflict of interest. Ensure arbitrators have no conflict of interest with the parties involved. Disclosure. Arbitrators disclose any potential conflict or relevant. In case you discover that you are having conflicting interests, all right, you have to disclose your interests. For instance, now you are to arbitrate in a matter that concerns me. I'm your friend, so you can say, I'm sorry, I may not be able to arbitrate in this matter because I don't know how fair I am going to be, because my friend is also involved in this matter, so I should be excused. Simple as that. You understand? Number of arbitration, or number of arbitrators rather. Number of arbitrators, single or panel. Decide whether to appoint a single arbitrator or a panel, typically 3. Do you understand? Typically what? 3. A panel can provide diverse perspectives, but may also increase complexity and what costs. Because if you hire 3 people to be arbitrate, you are going to pay more. Do you understand? But if it's 1 person, it's going to be less expensive. But the challenge there again is that if it's 3, they may come with different perspectives and experiences, but 1 person may just be his opinion and his experience. Selection process. Agreement by parties. We say that you have to write an agreement by parties, outlines the process, what is involved, and how it can be done. Institutional rules like AA, JAMS, ACA follow their rules for appointing arbitrators, which often include lists of qualified candidates. So you have to follow the rules of a Nigerian arbitration and conciliation, acts, so that you know how to appoint those that you have to appoint. You understand? It's very important. Geographical considerations. So you have to consider the geographical location of the parties involved. If you are even in Nigeria here, if you are in Abuja and someone else is in Lagos, and then maybe the matter is far in Lagos, it's going to be challenging for the person from Lagos to come to Abuja for such, and of course you to Lagos is going to be challenging. Do you understand? So, but geographical location must be considered, and if need be, then we should put it in such a way that it will be convenient for the parties involved. And if it's not possible, use online. Diversity and representation. Diverse perspectives come together to express themselves. Availability and commitment. Time commitment. Yes, you have to be available for case to take place, for the arbitration to hold. Review of arbitrators' profiles. Check and cross-check. Conclusion. So you have to select the right number of arbitrators with the right qualifications. Do you understand? And it will go a long way to help. Network is behaving funny. Roots somewhere. Tell the network to stop behaving very funny, because I know that you are ready for this class today. So network, just calm down so that Roots can enjoy the class. Thank you. So qualification of arbitrators. A legal expertise. Arbitrators should have a strong understanding of the law applicable to the dispute. Do you understand? The one legal expertise. Okay, let me say that even if you don't have expertise in law, you must have at least a reasonable knowledge in a particular matter that you are taking to arbitration court. You understand? That's number one. Qualification. Industry knowledge. You cannot go and bring someone who is a lawyer to come and talk about medicine when he has no knowledge of what medicine is all about. You understand? The industry knowledge is critical. It's a matter of consideration. Arbitration experience. So the arbitrator must have experience in the relevant areas where the dispute is to be resolved. Communication skills. Alright? Arbitrator must be able to communicate effectively and empathically. Do you understand? You must show empathy in your communication. You must communicate effectively. Appointment of arbitrators. Arbitration agreement first. Mutual agreement. International rules of engagement. Court involvement where necessary. Challenges to arbitrators. Challenges to arbitrators. What are the challenges that arbitrators face in trying to arbitrate? What are the challenges they face? Challenges for biases or impartiality. You understand? There are high tendencies that arbitrators may become biased, may want to show favoritism and nepotistic attitude. Do you understand? It's possible to start feeling like that and behaving like that as well. So it's one of the challenges that we face in arbitration, because the arbitrator may become so emotional and may tend to lean towards a particular party and then destroy. Lack of qualification is also a challenge. Sometimes people are being considered, but they don't have reasonable and adequate knowledge in the area they have been considered. They don't have what we call cogent. They don't have what we call cognate experiences. You understand? Cognate experience they don't have. They just come. Procedural issues. Irregularities can be a problem. So it must be must follow the right procedures. Grounds for removal. Most arbitration frameworks allow parties to seek the removal of an arbitrator on specific grounds such as incapacity. So once an arbitrator becomes incapacitated, he can be removed from or misconduct or failure to perform their duties. They can also. The last topic for today, we are looking at conduct of arbitration hearings. How do you conduct the hearing of the arbitration? How do you conduct arbitration hearing? Number one is what we call pre-hearing preparations. Pre-hearing conference often is a pre-hearing conference is held to discuss procedural matters, set the timetable, and clarify issues. This can help streamline the hearing process. You understand? So these are preparations. Do you understand? Pre-hearing preparations, and they are very important so that adequate arrangement will be put in place and all the procedural process are being protected. Submission of documents. So once the arbitration is set, the next thing is to submit document. All right, the relevant documents. All right, written statement, evidences, and witness list in advance. You have to drop them in advance before the matter is commenced. Then we talk about arbitration rules, which we have been talking about, to make reference to AAA, or JAMS, or case of Nigeria, ACA. Do you understand? Make reference to those laws. Know what the law says concerning a particular matter before you begin to execute it. Opening statement. Opening statement. Introduction. You have to introduce yourselves, introduce the arbitrators, your colleagues, and then allow the parties to also introduce themselves. And then opening statement. Each party present their cases, and then you listen as arbitrator. After listening with due consideration of the evidence provided, and take a decision. Presentation of evidence. Expert witness, cross-examination, questioning. You must know how to question very well. You must be a good examiner. All right. Re-examination. So you must be a good examiner. Questioning, re-examinations, and some of the things that you need to do. Closing statement. So summarization is very important. You have to summarize what has been discussed, the evidence being presented, and all those stuff. Then post-hearing submissions, written summaries, deliberation and awards. Issuance of award, very important. Confidentiality, private proceedings. You understand? Evidence presentation, the types of evidence you have to present them as you have. Submission of evidence, rules of evidence must also be given. Witness examination, direct examination, cross-examination, re-examination. Are we together? Submissions, opening statement, closing argument. So once you argue, say that you want to say, another person wants to present his case, then you come to the submission statement. So you make your own final statement, another person also make his or her own final statement, and then the matter is closed. Written submissions. So the arbitrator will write the written submissions about the parties, and they proceed. Do you understand? Additional consideration to also consider is confidentiality, tribunal rule, right? There are also issue of tribunals. So you have to consider all of this, because the arbitrator have the authority to manage the proceeding, including the admission of evidence and the conduct of examination. All right. So we have procedural rules which are there. Do you understand? So tomorrow we'll be looking at arbitration rules and procedures. Arbitration rules and procedures. All right. I hope you have shared the link. Today we started our visit some schools. Maybe we'll share the pictures later. All right, to carry awareness on the International Day of Peace. You see, this is the shirt I wear. Since I came back, I didn't even remove it. This is the shirt. If I turn my back, you see the International Day of Peace on it, written on it. You understand? I have not removed it. You understand? So throughout this week, that's what we'll be doing: outreach to schools, creating, you know, awareness. Any question? Thank you. Any question? Any question? For those of you that are in our WhatsApp group, we may share the pictures with you and maybe some videos for you to watch what we are doing. Or the videos, you can see them on Facebook or on YouTube. And then for pictures, we may share in the WhatsApp group, and you can also see them on our Facebook page as well. Thank you. Somebody's asking about the flyer. Flyer for... Which are the flyer? To become a member? Or which flyer? Flyer for convention? Flyer for discourse? Any other question? Any question? In the absence of any question, we'll call it a day. Because if you see me, I'm yawning. I'm so tired. I've been driving, doing a lot of things. People will hire a driver for us so that I will focus on other things. I'll be a driver, go do this one, drive home. So it's quite exhausting. But we thank God for grace and strength. All right. So any question? Okay, for the International Day of Peace, that flyer, I don't want to share it because it contains the distribution, that's donation for books. So I don't want people to have wrong impression. Maybe we'll create another flyer for it, because the one we have there, it contains some donations issue. So we don't want to share that one out since we have stopped collecting donations. So don't send us donation for the books again. We are done with that project. Okay. Any question? What are the procedures to become a member? You want to become a member of the institute, you take a personality test. Once you pass the test, then you proceed to pay your application fee. Then we'll process your approval letter after you fill the form. Then once you get your approval, they can pay your induction fee and also participate in the pre-induction training, which is 3 days training. But I will send you a link to join our WhatsApp group, Kingsley Agundu. I'll send you the link to join our WhatsApp group so that you can also you can get the details there. All right, in the absence of any other thing, thank you very much for connecting. We'll see you on Thursday. We'll not be meeting tomorrow because, all right, it will be sent favor. We'll not be meeting tomorrow because tomorrow is Wednesday. I'll be going for midweek service, and so I'll not be able to join the training tomorrow. So we'll meet on Thursday. Thank you very much. Have a wonderful night rest. Bye.